As assistant district attorneys?
Yeah.
There was Neil Robinson. Rick Goodell worked for us for a while. Dick Slater, shortly after I was elected DA, the public defender position became open. So technically he worked for me for a while, but then he left the DA's office to take the position as the public defender, which you might think is a conflict of interest, because if public defender left the public defender's office and became district attorney, the district attorney would be disqualified from any case that was pending in the public defender's office, because they could bring over to the prosecution side confidential information about in their files. Well, it doesn't work the other way. If a prosecutor goes to the defense side, no court has ever ruled that that's prejudicial. If anything, it helps the defendant, because now they got inside information in the district attorney's file. Well, I'm trying to think who else.
Did Ron Gibb, was he?
Ron Gibb was my first assistant DA.
And did that happen about the same time Slater went to become public defender, right?
Yes, Gibb came over from the public defender's office, and Slater, but we built a wall. I don't think that we ever had to disqualify ourselves from any cases. Just Gibb was not allowed to have anything to do or discuss any of information about any cases in the public defender's office. But yeah, he eventually, I appointed him, and Bill Foley worked under me for a lot of years. But because Ron Gibb was full-time and Bill Foley was part-time, I made Ron acting district attorney. In my absence or incapacity or whatever, he became acting district attorney. Or when I was on vacation, he would be the acting DA, and he would sign the indictments, etc. Trip Price worked for me for a number of years, and I think he had left the office by the time he passed away, but Trip was a piece of work, as you know.
Yes, indeed.
And we all loved him. We all loved him to death, and died at a way too young age. But he was, and he loved the kid with the secretaries. Tony Owens, my longtime secretary in the DA's office, and as my confidential secretary, my county court judge. Trip Price, I mean, he would rib her, and they'd rib each other a lot. And she loved him. She loved it when he'd show up. And back in the day, he could just walk into the judge's chambers. I mean, now it's like a prison up there. You got to have a magnetic card just to get in practically any room. And you don't get in the judge's chambers without a court officer ringing the secretary. The secretary is calling the judge, say, so-and-so is out here, has some papers that you need to sign or needs to talk to you about something, blah, blah, blah. So nobody got in until the judge says they could come in. It's completely different now, and the camaraderie is not the same as it was back when I first started out. You know, you'd meet up with lawyers, public defenders, other elected officials in the halls, newspaper reporters. Jim Fox, reporter for the Dunkirk Observer. I mean, he was one of the good old-fashioned reporters who would go from office to office, county executive, county clerk, whatever, DA's office. Jim Fox is here, he wants to talk to you. Send him back. He'd sit down, he said, what's going on? I said, we'd just start shooting the breeze. And then I'd bring up somebody, I said, you know, we're involved in this thing right now, and I'm not sure where it's gonna go. But he said, well, tell me a little bit more about it. And so I'd tell him about it. And I said, now, some of this you gotta keep confidential, but it's no secret that we're investigating. Blah, blah, blah. I said, what can I publish? I said, do you mean what's on the record? He said, yeah. And next thing I know, out comes the pad, and that's how he got his news. He would actually go from office to office, sit down, start shooting the breeze, and sooner or later, whoever he was talking to, interviewing, would come up in the course of conversation and mention something, and out would come his book. He says, all right, how much of this is on the record, how much is off the record? And he was the type of reporter that, I mean, we had some cases, some investigations going on where everybody was assuming one thing, when actually the truth was 180 degrees the other way. But everybody, and even the news media, was speculating. And I would do this with all the reporters that yeah, I respected. There were some Post-Journal that, I mean, Christy Herbst started out, I think, as a cub reporter about the time I started out as an assistant DA. She covered a lot of the homicide cases that I covered. And I think she retired shortly after I won my last election to the county court bench. But I'd call her or Manly Anderson, some of the people have been around for a while. And I just looked, there's a lot of speculation going on. And I've heard some reporters talking about doing an article and suggesting this is the way this thing went down, whatever it was. And I'd say, I'm going to tell you this. Don't go up that. You're barking up the wrong tree. And I'm not trying to hide anything from you. As soon as I can release some information, I will. But I can't now. But don't go speculating in the direction you're going. And I could do that with Jim Fox. I could do that with several reporters in Jamestown, both print and broadcast. And they always appreciated that. I said, don't waste your ink on that, because then you're going to have to print another article, almost like a retraction from the one that you put out in the first place, and you're going to look kind of bad. So I had a very good relationship with the news media, and so trying to think of any other assistant DAs. Trip Price was there.
Seidel.
Bob Seidel was there, and I think he stayed in the DA's office. I think he might have retired during Jim Subject's term as DA. I'm not sure, but of course he's deceased now. Boy, Greg, you put me on the spot here.
All right, well,
I'm trying to think of a lot of things you're going to ask me, and one of the things was not, who worked for me?
Minor.
But it rolled over. A lot of times they would come, and most of the job positions, the ADA positions, were part-time. So these people had private practices as well as working for the DA's office. And I think one of the reasons several would want to be an assistant DA is you would get trial practice immediately. It would be out in the justice court, but still you'd have to learn how to pick a jury, you have to learn how to do opening statements, closing statements, how to make objections. And it was a good way to learn. It's in justice court. I mean, the stakes are still, I mean, misdemeanor in justice court, misdemeanor is a crime. Somebody gets convicted of a misdemeanor, it's on their record. So, I mean, it's no small thing to work out in justice courts. Most people think of justice courts as speeding tickets and rolling stop signs. No, they handle first offense DWIs, which carries an awful lot of baggage with it if you're convicted, in terms of insurance rates, in terms of lawyers' fees, in terms of your license being lost. There's a lot riding on a driving while intoxicated case. So we had you know, I think most of the ADAs that worked for me stayed at least 2 or 3 years before they went on, before their private practices really started blossoming, and they just couldn't juggle both. But at that, I mean, with 2 exceptions, I'm not going to mention who they were. We left on good terms, but we're not on good terms. One never forgave me, but that particular attorney doesn't even practice around here. And the other attorney is still, I think he's retired now, but we stayed friends. But I said, things just aren't working out, you know, the way I want them to do, and want them to work out with you. And I just don't think you're a good fit in the office. I'm not saying you're incompetent or a bad attorney, and I would never, you know, I do not want to have to fire you. I would strongly suggest that you say, send me a letter that my private practice has gotten so large now that unfortunately I have to resign the district attorney's office. And I said, that's 2 things. First of all, everybody saves face. And secondly, let's say some DA down the road likes you a lot and likes the way you handle things and wants you to come back to the office. Nobody ever, you weren't fired, you voluntarily left. Now I'm voluntarily going back. So, that's, of course, Jim Subject was an assistant district attorney.
Talking about public defenders and a judge's relationship, I hearken back to a headline I think I saw at one point where Judge Adams and Ed Fagan had a kind of a running gun shoot, I guess, where maybe in the Sawyer's case, I'm not sure what it was.
No, I know the case you're talking about.
Okay, where Ed was not assigned, even though he was the public defenders, and they got brought in somebody else. And what case was that?
No, Ed was not assigned. He was retained counsel in that case.
Oh, okay, excuse me.
It was a sex offense case. It was a rape case. And I'm trying to think of what. I'm pretty sure it wasn't not the Sawyer case, because Ed never appeared in that case. There's Bruce Carpenter, and then Sawyer wound up representing himself because he wouldn't take
That's it, yeah.
Bruce Carpenter. And he was getting some advice from somewhere. Speculation is that it was from Ed. But he knew enough to say, I refuse to accept the services of the public defender, but I'm not competent to represent myself. Put the judge right in the middle of a terrible bind. But no, the case that Ed was involved in, I believe, was a rape case. And I don't know what the ruling was or what it was, but Ed thought the case was really bad. And then there was some issue about the identification. The victim had the size, the height, all wrong, but had made a identification in a lineup, and maybe it was Adams' ruling on the identification, I can't remember. But outside the courtroom, there were reporters, and had said this whole case is a mockery and a sham. Outside the courtroom, in the public corridor. Well, Leetown Adams found out about it because it was in the papers. Fagan calls mockery and a sham. So Leetown Adams brought Fagan in. I said, did you say that? Yes. Well, where did you say it? I said, right outside the courtroom. He said, if you just say it to. I said, it to the press. He said, all right, anything you have to say for yourself? No. All right, I'm holding you in contempt of court. I don't know if he fined him or what he did, but he found him in contempt. And I think, as I recall, Ed appealed that to the appellate division. I think that's where it would be appealed to. And whatever body it was, I'm sure it had to be the appellate division. They overturned it. It says, whatever the attorney says outside the courtroom is not contemptible. If it's in the court, while court's in session, say something demeaning to the court or to the judge or to the court system, the justice system, whatever, that possibly could be. But anything that an attorney says to the news media or anybody else outside the courtroom is not subject to a contempt proceeding, and they dismissed it. But yeah, I remember that very clearly. Adams was quite upset when Mr. Fagan said the whole thing was a mockery and a sham. And
did that set the tone between the relationship?
oh yeah. I don't think the tone was ever very, very good. Ed was very good at pushing the buttons of Judge Adams. And Judge Adams was the first to admit, if you talk to him in chambers, he said, you know, he'd tell me, I can't let him get under my skin like that. Talking about a particular attorney. There were a handful who just knew how to get under his skin. He says, you know, they keep repeating these things, and I know I shouldn't get mad, and shouldn't pound my hand on the bench, but that was him. He was temperamental and didn't like to be wrong, which none of us do, but he took it to an extra level because, let's face it, he was a very, very intelligent man. He was Phi Beta Kappa from Yale. I just got to tell you something.
Yeah.
And if you ever practice in front of him, especially if you were in chambers and he didn't have his robe on, that Phi Beta Kappa key was fully visible.
Yes, it was. I remember very much. You have so much. I mean, I pulled out the file, John, when we did our kind of retrospective at the Jackson Center, and it was just a wonderful event, so much so that I know people want to do it in phase 2, phase 3. I mean, there was so much stuff there. But as you got done with that particular session, of which we had representatives of the public defender's office and the DA's office.
Neil Robinson, Kevin Laumer, Dick Slater, Paul Andrews, myself, and Steve Cass was a moderator.
It was a who's who. And did you walk out of there, did you have reactions saying, gee, I wish we got into this case or that case? Was there something there that you said, because it was a packed house, full, everybody was enjoying it immensely. Nobody wanted it to end, but it had to end at some point. Was there any sort of afterglow where you said, gee, I wish we'd talked about...
No, I think there was an afterglow, but in a positive sense, because a lot of the attorneys that were in the Jackson Center at the time, in the auditorium, were just kids or maybe hadn't even been born when I first started practicing law. And things have changed so much, I think it was very enlightening for them to see how things worked back in the day before we had DNA evidence and a lot of the scientific proof that people expect today just from watching TV. You know, they expect DNA to show up at a trial, things like that. So I think it was, my reaction to it was very positive. And I can't say that there was any particular issue, any particular event, any particular case that maybe we could have talked about. Yeah, there were other cases that were interesting that we could have talked about, but that would have, I mean, if you really want to get into all the cases that I handled over the years, we would have been there all afternoon. And I remember you telling me afterwards, after people were filing out, you said you took a seat way up on the top in the back row. And you told me, he said, I did never not see one cell phone go on during the entire proceeding. Now that to me is a sign of a successful program.
No question, and that's all true.
And you put it together, and you chose an excellent moderator in Steve Cass, because he did a tremendous amount of research, and he knew the questions to ask, and he had even talked to me a little bit before the actual presentation, just to make sure he was on the right track about things. But I thought he did an excellent job of moving things along, but not trying to steal the limelight. And Steve is a good friend. We've known each other for a long time. And he's no enemy of the limelight, but he knew what he was supposed to be doing. He knew what his role was in that presentation, and he did an outstanding job. And I congratulate you and him for, I think it was a very excellent, the panel that you chose were all gray-haired, been around a long time, seen a lot, and like you said, the audience was rapt. They just, you could tell that they were just really enjoying the heck out of the whole thing.
They were, and it's on YouTube for those that want to watch it. You write opinions, and occasionally, you know, because you make an opinion, you make judgment calls, you make decisions on motions, and the appellate division has a chance to appeal. They have a chance to look at it. Was there one or two that kind of came back where they reversed you and you said, you got to be kidding me? I know that's never easy to get a reversal, but nevertheless, one where you said they're really off track.
Well, first of all, you have to you understand this, but you know, anybody that's viewing this that's not in the legal profession has to understand that a reversal 99% of the time does not mean the case is dismissed. It means it's sent back for a new trial because of some error, usually made by the judge, either in allowing some evidence in or disallowing some evidence that should have been let in. Interesting story. It was a reversal and a new trial ordered. The same man from Erie who took the swing at Tony Caprino, who had been charged with murder, who Bruce Carpenter tried to get off on jurisdictional grounds. As it turns out, it went to the appellate division on appeal. And I think Ed Fagan at that time had assumed the role of public defender. And this was several years. I don't know why it took so long for them to perfect the appeal, but in criminal appeals, there's no statute of limitations, no deadline. You can wait for years and years and perfect it. Not like civil appeals where you have a certain amount of time, otherwise it's going to be deemed abandoned. Criminal appeals, they can languish for years and then somebody can pick them up. But anyway, it was a number of years. And what had happened was it was nothing that Leetown Adams did wrong or anything that I was prosecuted the case, anything that I was accused. What happened was a search warrant was issued by a judge in Erie, Pennsylvania for his apartment. And environs or surroundings or whatever. And so the search was not only of his apartment, but they were looking in his mailbox, they were looking in the hallway, they were looking around other places other than his apartment. And the appellate division said, and I can't remember what the exact term was, but it was too broad. The judge out there in Erie, not Leetown Adams, not a judge in Chautauqua County, an Erie County court judge, issued a search warrant for the police that was too broad. It involved environs in areas where there's no way they could find any evidence of wrongdoing, where he may or may not have had an expectation of privacy, but obviously they found that he did. So they sent it back for a new trial. And I had to call this young lady that was murdered, came from the nicest family. And they sat through the trial, and they lived from Erie. And that decision came down that we had to try the case over again. And I was crushed, because not that I had to go through the work again, because the family would have to sit through this trial again. So I called her parents' home. Her father answered, and I said, I've got some devastating news. It's not hopeless. It's just we're going to have to try that case over again, because the court held, and I tried to explain to him what the ruling was. Later that day, we find out that either Ed Fagan himself had gone to Attica, or one of his assistant DAs, or maybe his investigator, I can't remember, because Ed was public defender at the time, had gone to Attica to inform the defendant that that the conviction had been reversed, he's getting a new trial. Found out that the defendant had died 2 years earlier in prison.
Oh, no kidding.
So I went, and as soon as I verified that, I got a hold of the Department of Corrections and the prison, and yes, he is buried in the pauper's field outside the gates. And so I called the father back, and I said, you know, I think you're going to consider this good news. Even though he was not convicted, he died in prison 2 years ago. And her father said to me, those are the two worst and best phone calls I've gotten in one day in my entire life. And I mean, you don't want to make light of somebody dying, but the fact that they didn't have to go through the trial again. And Ed Fagan, if you knew Ed, he always had to put a positive, try to put a spin on it to make his side look like in a better light. And I remember a headline in the Post-Journal within a day or so. Ed Fagan, so-and-so died, an innocent man.
Oh my God.
Which is technically true, because he had not been convicted yet.
Right.
We would have still had the same proof and the same, but so that was a reversal that was crushing, but finding out we didn't have to retry him, that he was no longer a member of society, no longer a threat to anybody, even though technically we didn't have a conviction. You know, he's dead. Who really cares now? You know, and there was another one that came back that involved a guilty plea of an arson case. A fellow set fire to a house with a family that was actually home. And for some reason, even though their bedroom was upstairs, for some reason the husband was staying up later or couldn't sleep or was trying to, but he was on the couch. And he was awake and he heard this noise on the front porch, and he looked out there and he saw the defendant doing something. He couldn't tell exactly what he was doing. And next thing you know, there were flames shooting up. And the house burned down, but everybody got out safe. The one child was away in college, but the mother was there, the husband, and one son. And they got out, and the case was very strong against, it was a neighbor that they had disputes with, for a long-standing period of time. And different sheriff's deputies were very familiar with this man because they'd been called out there for different reasons. This guy was just a pain. And it came time the day for trial, and we're trying to get it settled. And I think the maximum was like 25 years for first-degree arson. And I think the DA's offer, if he pled to the charge, was like between 15 and 20 years. And I said to the DA and the defense attorney, I said, I'm okay with that, but if he pleads and does not put the family through the trial, he's an older gentleman. He doesn't have much longer to live anyway. I said, I'd be willing to tell you, I can't remember if it was Ned Barone or who it was that represented him. I said, I'd be willing to go lean closer to the 15 years than maybe the 20. I had in mind like 17 years, which would probably extend beyond his life expectancy. Of course, knowing him and the type of person he was, he may have wound up getting killed in prison anyway, but that's just an aside. We have now in New York State, for most offenses, they eliminated parole, where you serve the minimum sentence, like, let's say it's 8 1/3 to 25 years. After you did 8 1/3 years, you're eligible for parole. You appear before the parole board. If you've been a model inmate, if the crime was not particularly heinous, and you've shown forgiveness and regret and remorse, you might not get parole the first time, but you come back before them every year. And so you're eligible after, my example, 8 1/3 to 25. You're eligible after you do the minimum. And they might hold you in for another year or two. And then for the remainder of that 25 years, you're on parole. You have to report to a parole officer on a regular basis. They test you regularly, randomly, for any alcohol or drug usage. And if they do find anything like that, parole would file a violation of parole. You get sent back to jail, you'd have a hearing, and then if they find you were a violation, they could re-sentence you to some additional time. Now they have what's called definite sentencing and what's called post-release supervision instead of parole. It's kind of semantics in a way, but now if you sentence someone to 20 years, they have to do, the way it works, it's supposed to be you do the 20 years, but the way they've got it calculated, you do, I don't know how they came up with this, you do 6/7 of the sentence, okay? So let's say the maximum was 21 years, 6/7 of that would be 18. Then you can get released on post-release supervision in the statutes, the criminal procedure law depends upon the nature of the crime, the degree of the crime, be anywhere from 3 years up to 10 years of post-release supervision, which is just like parole. But when someone enters a plea, it has to be clear on the record that the judge, the defendant understood what the post-release supervision was going to be. And this arson case, the first time, the man pled guilty. And I think what we finally agreed to was 15 years on a plea with 5 years post-release supervision. Dave Foley was the DA. He put it on the record. And I believe I put it on the record, but then the guy wanted to think about it. So he went back into the holding room to talk with his attorney some more. And then finally he came back out and his attorney says he's ready to take the deal. So I explained all his rights to a trial and everything, went through the whole thing. But since we'd already talked about post-release supervision on the record, it was right on the record, but it wasn't exactly at the time of the plea. The appellate division says that plea was faulty, and they sent it back for a trial, because this was a guilty plea. So then we had to go through an entire trial. He was ultimately found guilty after a trial, but I just felt bad that the family had to be put through it. But I mean, nobody was killed, nobody was hurt. But it was a tough time for them. But they were very strong family, very strong-willed. And so anytime you get a plea, that you think you've done everything right, if that gets reversed, which is rare because, you know, there's a whole catechism that you go through and you take a guilty plea. You try to cover everything as a judge. And we had covered the post-release supervision numerous times, but because I didn't put it on the record at the time he actually entered his plea, appellate division says, no, not good enough, send it back. So anytime you make a mistake like that, taking a plea, I mean, making a mistake at trial when you have to make a split-second decision, a lot of times the appellate courts will say, you know, given the weight of the evidence in the case, yeah, that was error, but it's harmless error, you know. But when you're taking a plea and you've got time to think and go over everything and you got an outline, which, you know, you use it first, but then you got everything memorized. But I forgot, just did not think I had to put on the terms of post-release supervision because it had already been discussed. He'd already knew what it was going to be. And said, no, that's not good enough. You got to say it right before he pleads guilty. Oh, that, I wasn't too happy with the appellate division after that one.
I can imagine. Do I have this correct, that at some point you were at the Hogan's Hut, and did you get, was there an attempted assault?
It was actually a murder.
Was it?
Well, okay, no, there was an attempted assault on me.
Right, yeah.
The same individual who Ed Fagan made the comments about the trial case being a mockery and a sham. His case was still pending and he was out on bail. It was a rape case, but his family came up with bail money. I knew the guy. I went to high school with him. He knew me. I knew him. We were always friends in high school. We even hung out together sometimes. Anyway, I was sitting in, back then, the town North Harmony highway superintendent was a fellow by the name of Bob Pickett. And his truck was sitting outside, and I think I was getting gas there or something. He came out and he got in my car and we were talking. And the defendant, who was out on bail, sees my car and sees me there. Now, he was a very, very active muskellunge fisherman. And he always carried with him a club. So, you know, if you catch a muskie, they're dangerous. They bite. They got teeth. You got to take them out as soon as you get them in the boat, or you could wind up with a serious injury. But he would carry this around, and I was in my private car. This is before I had a county car, but I did have a police radio. And the first thing he did was that muskie club, and it was about that big around, and maybe at least 3 feet long. The police radios back then were a little bit larger than they are now. First thing he did was smash the antenna off the back of my car for that police radio. So I had very little broadcast ability because the antenna, you know, is essential to the use of the radio. So then I said, you know, and he started complaining how he was innocent and wrongly accused. I said, Jerry, his first name, I'm not going to say his last name. I said, you've got a good lawyer. You've got a fair judge. You've got a good, Neil Robinson was the prosecutor. I said, he's a fair prosecutor. You're going to get your due date in court, and if you're not guilty, the jury's going to find you not guilty. Well, he was just irate. And he had started to threaten me, and I just took off. And my friend Bob Pickett was in the car with me. And I went back then, as before the new highway was put in there, and you could actually go around the block and past where the town court building used to be, and there's a Four Corners behind Hogan's Hut. And there was the defendant, and he was reaching down into a snowbank, and Bob Pickett was with me, says, he's going for a knife. And sure enough, he pulled up a Bowie knife about that long, and he threw that right at my car, and it came point first right at the post between the windshield and the driver's side window, and it cut through the metal and then fell to the ground. If that had hit the glass, there's no question in my mind, maybe not the windshield, but if it had hit the side window, because the car was kind of at an angle, I think there's a good chance it would have come through and it could have caused me some injury, I don't know. But he was eventually charged with an attempted assault for throwing a knife at me. And our office prosecuted it. And I was thinking the other day, if this did come up, why we didn't ask for a special prosecutor. If I was a victim, it would seem to me that my office shouldn't have anything to do with it. But Ron Gibb wound up taking the case, and Ed Fagan represented him on the assault case. In the meantime, he was acquitted on the rape charge by a jury. He was found not guilty. So all they had was this attempted assault second, which is the lowest degree felony there is, a Class E felony. Gibb came into my office one day and said, look, they're willing to plead to a couple of misdemeanors and take probation. His mother, who lives in Buffalo, is going to have him come up to Buffalo. He's going to live with her. He'll be out of the area. Do I, as the victim, have a problem with that? I said no. I've known that man all his life. I said he was out of his mind, that day temporarily. Thought he'd been wrongly accused, thought I was behind it, and he wasn't thinking rationally. I don't think, to this day, thinking back, that he, in hindsight, wished he hadn't done it, not just because he got charged, but didn't want to cause me any personal harm. So they're willing to plead to some misdemeanors with probation, and he did some amount of jail time before he got bailed out. And I said, listen, I don't care. That's fine. Take it. I don't think he's going to be a problem again. So he did, and maybe a year or so later, I was going into the, somewhere over in Bemis, and I was going in with Tony Caprino and Jim Young, who was the chief of police of Lakewood at the time, and myself, maybe somebody else. We were going in the casino to get some wings or something. The casino in Bemis, not the Salamanca. The casino in Bemis Point. I think we were going to go in there and get some wings and maybe have a beer. And the defendant who'd thrown the knife at me was fishing right by where the ferry landing is. And Jim Young, who was the chief of police at Lakewood at the time, about 6'6", big guy. Bigger than the guy that threw the knife at me, who was no shrimp. He went over and started talking to him. And he signaled to me, come on over. And I hadn't said a word to this guy for a year at least, more. But apparently he was back living in the area. I don't know how he got back here. Wasn't that concerned. I wasn't afraid of him. But so I walked over there, and this guy said to me, he said, I've been meaning to do this for a long time. I'm really sorry for what I did. He said, I think he said, I was out of my mind with worry, with anger. I couldn't believe this was happening to me. I did not commit that crime. I couldn't believe I was going through all this. And he said, I really feel bad, and I'm sorry, and I hope you can forgive me. And from then on, I'd run into him in the post office at Mayville once in a while, or at Tops or Quality, whatever the store was in Mayville. And we talked, we chat, we got along fine. It was forgotten and forgiven. And so, but that's the only time that I was ever, I want to say assaulted, but any attempted assault was made on me. There was a fellow here in Jamestown that used to write letters to judges and DAs and other attorneys, and I'm not going to mention who it was because he's been really quiet lately. But myself, Neil Robinson, and Judge Adams, we were the Mayville Mafia. Hated John Lamacuso, the Jamestown City Court judge, because he'd been in front of him for some minor charges. Got in a fist fight with Phil Callow one time. He was just angry, but he never followed up on any of the perceived threats. What we do when you're a judge, you get a threat like that, you turn it over to the head of court security. They in turn make a copy of it, keep a copy, send the original to the head of security for the entire state court system, and they'll start a file on this individual. Both the local authorities will, and if necessary, they'll come down and investigate, interview, assess the threat. But no, I never had any problems. I did. I would not say anything then. I would not discuss any measures I took as far as personal security. But I did, when I was working as DA and as judge, carry a firearm. I would never carry one in court. I always had a had a lockbox in my desk, and I would lock it up in my desk. And it was just, I had to hit 2 digits and I can open it if somebody broke into the chambers and, were intent on causing any bodily harm. But I did carry a firearm for a lot of years, practiced with it frequently, oftentimes with the Sheriff's Department or the Probation Department. They have a range up in DeWittville. I qualified. I didn't take one of the courses that most people qualify to get a permit. I got the permit shortly after this fellow threw the knife at me. And I qualified at the Jamestown Police Department shooting range. They had an indoor range. And Ron Cotton, late Ron Cotton, was the range officer at the time. And he took me through all the paces. I didn't take the 1-hour course or whatever you take, 2-hour course or whatever it is to get a permit. I took a course from a seasoned police officer, firearms instructor. And so rather than having a certificate from a licensed instructor, an NRA licensed instructor, I had a letter on police stationery from firearms instructor Ronald Cotton that I sent in with my application and went right through. But I mean, getting back to that incident at Hogan's Hut, when we left and we were going around the block, Bob Pickett's truck, he had a town truck, and he said, "I have a pistol underneath." He was licensed to carry. He said, "I have a pistol underneath the front seat of that car. If he gets into my truck and finds that pistol, oh, hell can break loose if a guy gets a gun in his hand." So that's where we're going. We're going back around to try to get to Hogan's Hut so he could get to his truck, get his truck the hell out of there, or at least retrieve his firearm, because we didn't want this fellow to get his hands on it. But no, after he threw the knife at me, then he just took off, and I called the Sheriff's Department. They sent an investigator down to my house, which wasn't too far from there. Took a statement from me, and ultimately the charges were filed, and they were disposed of, as I explained to you. And we kissed and made up in later years.
John, I talked a few days ago about you coming in here, and you're gracious in coming in today. Are there questions you anticipated I would ask that I haven't?
No, I anticipated that probably you would ask maybe more about the progression of my career and how I came from assistant district attorney to county court judge. But I think during the course of our talk here today, we've pretty much covered that. The death of Paul King. When I was elected district attorney, I took office in January of 1978. I was 29 years old. And I think it still holds the record as the youngest district attorney in the state of New York. Larry Himmeline came a close second, but I think I beat him out by a year. I think he might have been 30 when he was elected DA in Cattaraugus County. But yeah, so my career, assistant DA, then district attorney for 15 years, then county court judge for 23 years. Total of 7 countywide elections that I had to go through. And
do you ever pause and kind of say, that's remarkable?
What's remarkable to me is how fast it went by.
Yeah.
I mean, 40 some years altogether in the criminal justice system. Seems like it just went by like that.
Yeah.
But it was the strangest thing. I think one thing I thought you might ask me is, why did you decide to retire? First of all, the last time I ran for judge, I was 64 years old. The term is for 10 years. For county judges, it's a mandatory retirement. It's right in the state constitution. Mandatory retirement at the age of 70, okay? So I could have only served 6 years of that term anyway, which I thought might become more of an issue in a campaign, but it wasn't. There was some other issue that was brought up. But I was halfway through that 6 years. I was in my 23rd year. And I remember as clear as yesterday. I was actually taking a shower, getting ready to, get shaved. I usually shaved in the shower and get ready, dressed, and go to work. And it just hit me. I don't want to do this anymore. And it was like out of the clear blue. And people had told me that. They say, someday it's just going to hit you out of nowhere that you're done. you don't want to do it anymore. And that's just the way it was. And I gave the state my notice. I gave them a month's notice, I think, later on in that week. And that was it.
John, I forgot to mention the fact, I'm reading the article that appeared, Judge Ward to retire July 30th, and born in Massachusetts.
Yes.
What brought you here?
I was born in North Adams, Massachusetts, which is in the northwest corner of the state, just over the border from Vermont, not too far over the border from New York State. And it's just on the north end of the Berkshire Mountains. Beautiful area. My dad was a salesman. He actually ran a radio station in North Adams for years. He owned a radio station. Then he went to work for a car dealership. And then he got a job with a pharmaceutical company, selling, calling on doctors, trying to get them to prescribe their products, and then going to drugstores and make sure they were stocked with what they needed. And he was transferred and I can't remember how old I was, Greg, but however old you are in the 5th grade, I started 5th grade at the Northside School in Geneva, New York. That was his first territory, was based in Geneva. After a couple of years, they moved him to Western New York. And we initially lived in Falconer for, I think I went to 6th and 7th grade in Falconer. And then, of course, we all loved water and the lakes. We'd all lived near lakes, went camping. A church camp always had a lake. My dad was waterfront director. So we saw a house for sale up in past Asheville, not on the lake, but real close to the lake with lake rights, right away to have a boat. And a boat came with a house. So he bought it. And we moved up there, and I started at Chautauqua, the old former Chautauqua Central School, in 8th grade, and graduated from there before it merged with Mayville Central School. So it was actually my father's career that brought me out here. And I always consider, even though I wasn't born in Western New York, I pretty much grew up here. Most of the friends that I have that are still alive are from the Western New York area. But that's the story behind that.
The case that I forgot to mention, and it's the one that's highlighted in your article, Looking Back, County Court Judge Recaps 40-Year Career with you and Jackson right behind you. For many, no other case rocked the county more than the murder trial of Anthony Rob Taglianetti II, a Virginia man who was found guilty of murdering Keith Reed Jr., Clymer Central School. We should probably talk a little bit about that. That was one of your last cases.
I think it was my last murder case, my last homicide case. And just to give you an example of the difference from when I started and tried my first murder case was the fellow that took the swing at Tony Caprino. We didn't have DNA evidence. Obviously we had fingerprints back then, but you had to have something to compare them to. And they had to be some fingerprints at the crime scene. There were no fingerprints where this young lady's body was disposed. But one of the hardest things now about a high-profile case is jury selection. Mm-hmm. Because back then, as far as pretrial publicity, and jurors having formed opinions, prospective jurors having formed opinions, it was either what they read in the newspaper, what they heard on the radio, what they might have seen on television, or maybe discussions at the workplace, things like that. Now with the explosion of social media, Facebook, Twitter, all of those things, we had, with the Keith Reed homicide case, we spent more time during jury selection talking to these prospective jurors about how many people they had discussed this with and over what medium. And it is just amazing how much people are using social media and getting information equally, or if not more, from the news media. And so what we had to do is, jury selection took a long time. Our first series of questions had to do with what they had heard about the case and whether or not they'd formed any opinions. And we questioned each juror individually outside the presence of the rest of the jurors. We would take the juror into the jury room, which is just outside the courtroom. The other jurors sitting in the box or in the courtroom, stand up, talk, relax, we're going to be a few minutes. We'd take the jurors in one at a time. The defendant obviously had to be there, his counsel, the district attorney, and a court reporter. Everything has to be on the record. And we would go through, and at first it probably, well, sometimes it wouldn't take long at all. Listen, I've talked to so many people about this. I'm from the Clymer area. I knew the family, I knew this, I knew that. Okay, go back to your seat. Didn't want people just to get out of the room and walk out of the court. Go back to your seat, but you will be excused. But we excuse everybody at one time. We're not just going to start sending people out. But a lot of times we'd have to, it was excruciating, Greg, that the questions we had to go through and delve and find out who they talked to and how, and like I said, through what medium or media they had gotten their information and what opinions they had formed, because that's just, whether they had an opinion about the case is just the first step. The second step is that opinion something that is going to affect how you deliberate? Have you got your mind made up? Or can you, as we say, for a want of a better expression, put that opinion aside and come in here with an open mind and understand the presumption of innocence and that the prosecution has to prove guilt beyond a reasonable doubt. And whatever opinions you may have, you understand that that's just an opinion and it's based upon what you've read, what other people have said. It's not based on any evidence that you're going to, we'd have to go through all of that and try to get them to say, not try to get them to try to find out whether they are of the mind that they could say, yes, I have formed an opinion from what I've read and everything, but I understand that, that's not what counts. What counts is what happens in the courtroom. Of course, the defense would always try to challenge them for cause, number one. That means you have to have a reason. Hey, the person's got an opinion, can't be a fair juror. But wait a minute. The DA would say, wait a minute. The person said, I can put my opinion aside, I can be a fair juror. So, all right, no excuse for cause. But you can bet they'd use one of their peremptory challenges, which, as you know, for a peremptory, you don't have to give a reason. You get so many peremptories. For a murder case, there's like 20. Challenges for cause, there's no cap on those. If you could challenge for cause all day if you've got the grounds to do it. So it's not so much a matter, in this case, a lot of people had opinions from what they'd read and what they've talked about. And how if you read it in the media and then you're in a workplace with a lot of people, how word spreads and things can get misconstrued. And so we spent a lot of time. Each juror we questioned individually about what they knew. And then we put them all back in the panel. And the ones we knew we were going to excuse, they didn't spend any time questioning them. But then we get into some of the general principles of law that apply, and could they, follow the presumption of innocence and all of that type of stuff, and different things about maybe their careers. But the longest part was the individual part where we would ask them about their knowledge of the case. And like I said, since the explosion of social media, jury selection has taken on a whole new demeanor, a whole new dimension, I should say, because there's so much more you have to explore and how they may have come to any knowledge of the case.
You were quoted as saying one of the biggest challenges now and going forward is the explosion of electronic age and social media, and having law try to catch up with it.
Exactly.
Yeah, as you mentioned, following the jury. Did you have to put a gag order on any of the attorneys? Because there was so much national media attention on this case, probably more than you'd ever seen in Mayville, I would guess.
I never felt it necessary to issue a gag order. The DAs, I had two district attorneys during my term, Jim Subject first, and then Dave Foley, who is now the county court judge. As district attorney, you're going to get enough publicity about the case without issuing press releases or anything. You just the news media wants to know how the case is progressing. You can't discuss the facts of the case, things like that, because you're creating your own problem in jury selection by doing that. I don't ever recall having to put a gag order on a defense attorney. Most of them were most comments made by defense attorneys were of benefit to their client, okay? No, he's not guilty, or she's not guilty. No, they don't have enough evidence. So they're not necessarily poisoning a prospective juror's mind against them. They're trying to do just the opposite, get people thinking that, wait a minute, there are two sides to this. You know, even though they're not really, as you know in the law, the prosecution bears the entire burden of proof. People come into a trial thinking there are two sides and they want to hear both sides. And naturally, defense attorneys aren't just going to rest after the prosecution rests. They got witnesses to call. They got experts to bring in. They want to at least create a reasonable doubt in a juror's mind. But so any comments that the defense would made wouldn't necessarily poison a juror's mind towards guilt. But I don't ever recall, an excessive amount of that type of publicity, coming from out of the prosecutor's office or the defense attorney's office, that I had to feel I had to put a gag order on. I may be wrong. There may have been a case, but the one case I'm thinking of is Nushan Williams. That got national publicity. He was the one accused of having sexual relations with a lot of young women from the area, while he knew or should have known that he was HIV positive. And all I know is the DA was being interviewed by satellite trucks right out in front of the courtroom or courthouse. And I said, Jim, subject was the other time. I said, Jim, I hope you got enough discretion that you can tell him what the process is, what the procedure goes, but you just don't start talking about, what evidence we have. But I think in that case was very interesting, and I think they've changed the penal law since then. It was hard for the district attorney to come up with a charge that actually fit that particular crime. Some people should say it's attempted murder. Well, attempted murder means you've got to come almost close to having committed murder. And first of all, they had to prove that he knew he was HIV positive, and I don't know if they could even do that. And then just because you're HIV positive and you have sexual relations with another doesn't necessarily mean you're going to pass it on. And so it's just attempted murder, attempted assault. I think they finally wound up charging him with some type of attempted assault charges. None of which, even though they could be consecutive, because there were some of these women did not even want to cooperate, these young ladies. Oh, they got in the limousines, they flew to New York City to be on the TV shows, so they get their 15 minutes of fame in the hotel room and everything. But several of them did not want to cooperate with the prosecution. But it was tough to come up with a charge that actually fit what he did. So whatever he came up with, whatever the district attorney came up with, he pled to, and I gave him the maximum consecutive whatever I could do, but I don't think it came to much more than 10 years. So then he gets released. As Paul Harvey would say, what did he say? The rest of the story. They have now what they had in New York State, what they call civil confinement. And it's brought by the state attorney general's office, not the local prosecutor. But if they find that someone has served his or her sentence, but still constitutes a dangerous threat to society, they can bring, I guess you call it a charge, but it's really a civil action, before a jury of 6 instead of 12, which is a criminal action. And it's brought in Supreme Court, and the Attorney General's burden of proof, I believe, is by a preponderance of the evidence, like in most civil trials, not beyond a reasonable doubt. Well, they brought one against Nushan Williams, who also went by another name. I can't remember what it was. I think it's something Johnson. But, and the jury found that he was, in fact, a dangerous individual. And to my knowledge, and they're entitled to a review of that finding by a court every 2 years, maybe. A court can review the transcript, can review the proceedings, not necessarily a new trial, but it is reviewed, not necessarily, I don't think on appeal, but you can apply to a court to have it reviewed and be released. to my knowledge, he has not yet been released. He has spent a lot of time in prison. And yeah, no, he's still there.
You know, John, this has been tremendous education. You should be a teacher, aside from everything you've done, but just you explained it incredibly well. That last thing, I had no idea about the civil aspect of that. That's fascinating. This could go on forever.
It could.
Yeah.
I mean, 40-some years. I mean,
You know, you've got so many cases, and I look at the stuff that we talked about with all the other people. We should probably do a second aspect of it, get everybody together. And kind
I think you should quit where you're ahead. I don't know if you get as many people coming to the second. Well, I don't know. I may be wrong.
No, it was a big show. But it's sort of a kind of a legacy question, and they're always very awkward to ask and even more awkward to answer. But 40 plus years of public service in the criminal law world, do you kind of look back and say, this is what I experienced and what I did, this is what I hope I accomplished? Some reflection on that? Do you think about that?
Well, I don't sit around patting myself on the back, but yeah, I do sometimes reflect back on several of the cases that I handle as both prosecutor and as a judge. And I feel, for the most part, that I did a respectable job in both positions. Not perfect, you know, none of us are, and I wasn't a perfect prosecutor, I wasn't a perfect judge. But I always gave it my best. The best judgment that I had, what I thought was the right decision under the law, under the facts, whatever. And as I look back at my career as one that was very rewarding. And even though it was not something that I intentionally set out to do, I'm glad that I fell into it. And once I was hooked, I knew, I knew that's what I wanted to make a career out of. And of course, it wasn't becoming DA at age 19. I expected that someday Lee Town Adams would retire, Paul King would run for judge, and I'd run for DA, although at a much older age. But things worked out differently, and unfortunately, Mr. King died at the age of 38. But I feel a sense of satisfaction as what I've been able to do. I think, you know, we've talked about Lee Town Adams and, you know, sometimes his temperament, but I'll tell you what, after he died, the Post-Journal did and I think Christy Herbst was still editor, and I think she wrote it, I'm quite sure she did, a very positive editorial about Lee Town Adams and how lucky the residents of this county were that after he served as a lieutenant in the submarine corps in World War II. And I'm a little claustrophobic, and there's no way on this God's earth that I would get in a submarine and go underwater. So I give him a lot of credit for that, for serving. But she said that this county was fortunate that he came back here, practiced law for a lot of years, and then was elevated to the bench by that first landslide. And it was it was a very nice tribute to him that she wrote. And I was glad because all in all, when I look back on Lee Town Adams' career, there are a lot of things about how he conducted himself on the bench that I emulated, that I copied, that I thought were the right way to handle things. The one thing I tried not to do was ever lose my temper, because I never wanted any lawyer to think that I had any buttons they could push and try to goad me into making some kind of a mistake because I was mad. Now I might go in and yell at my law clerk and take it out on him or her. No, I never took it out on anybody. That's my temperament. I just don't easily get angered. And believe me, people have tried. And that's a tactical maneuver. It's nothing personal, but they want to go to judge into getting mad and maybe making a rash decision that later on, possibly on appeal, is going to work in his or her favor. So I'm glad I did what I did, and I think I served the county okay. Well, you know, I think, you know, the people who followed me as DA, subject, and Foley both did excellent jobs in those positions, and I think Dave Foley is doing a very good job as county court judge right now. It'll be interesting to see how he and the new district attorney get along, because the new district attorney used to actually work for David Foley.
Yeah.
And then I believe at some point he resigned. I'm not even sure why. But now he's going to be appearing before him. So, but Dave Foley's not, I mean, he's a good judge, and he's trying his best, and I think he's doing a good job. From what I've heard, not only from what I read in the paper and everything, but I get together periodically with Paul Andrews, who's one of my former law clerks, and Grace Hanlon, who was my law clerk and is currently Dave Foley's law clerk. And I get a lot of the inside scoop on how things are going up there. And I know she has a lot of respect for Dave Foley and the way he's conducting himself. So if she does, then I know he's doing a good job, because she's nobody's fool. If you know Grace, you know that.
No question. Well, you served the public incredibly well, John, and I'm just so thrilled you shared many of the stories, and we may pick up on some cases in the near future. So thank you for all your time. I appreciate it.
Glad to do it.
Thank you.
It's nice I think it's great that you are, not just because of me, but you are creating these legacies for the legal profession. That a lot of the young people years from now, I wonder what it was like to practice law back then. I wonder what it was like to, or to be a prosecutor or a judge back then. And I think that what you're doing is really great. And I'm not just blowing smoke. I really think, like I said when we came in, I'm surprised you have time to practice law. I looked up your name on one particular website and saw that you have received 21 honors and awards of different types over the years. So I say to you, congratulations for what you're doing, not only in the legal profession, but to helping preserve the legacy of the legal profession.